Welcome everybody to this latest edition of In-House in Focus. I am your chair for today's session. My name's Alex Newman. I'm an intellectual property lawyer here at Mills and Reeve. I essentially have two jobs to do today. Firstly, and most importantly, I'll be introducing you to our speakers and introducing the topic. And I'll also be covering the housekeeping, which those of you who are familiar with these sessions will have heard many times before. So I'll apologise in advance that you'll end up hearing it again. As I said, most importantly, first of all, I'd like to introduce you to our speakers. So we are joined today by Katrina Anderson, who is an expert in consumer protection, particularly in a digital and e-commerce context. Katrina is joined today by Paul Hilder, who also advises in these areas. And they're going to tell us about the consumer protection related aspects of the Digital Markets Competition and Consumer Act. Now, the Act does have profound implications for consumer protection law. Katrina and Paul are going to explain what the new obligations and enhanced sanctions mean for businesses who interact with consumers. As the name suggests, the Act also has implications for competition and creates a new digital markets regulator. If you're interested in those aspects, then we'd encourage you to look up the session from last month's In-House in Focus, where the competition team addressed those issues. Katrina and Paul today are just going to be covering the consumer protection aspects of the Act. So please do bear that in mind, particularly when asking any questions. Try and keep those to the consumer related aspects, please. Moving on to housekeeping, as ever, there will be a recording of this session available after the session. It will be uploaded as soon as possible. I believe we send links. If we don't send links, I should probably know that. You'll be able to find the recording by Googling. I find it by Googling Mills and Reeve In-House in Focus and accessing the links that way. As you'd expect, it appears at the top of the search results. Q&A, we will be doing a Q&A at the end of the session. Could I ask you all, please, if you do have a question, please use the chat button at the bottom of your screen and type your question into the chat function. I will then field and pass those questions on to Katrina and Paul at the end of the session. Can I also ask, if possible, if you could mention when asking the question which of the slides your question relates to? That makes it much easier for Katrina and Paul to understand the question in its proper context. Also, if you don't mind, if you could include your name. I won't disclose to all other attendees who has asked the question, but it means that if we don't get to your question, we don't answer your question during the session today, Katrina and Paul will be able to respond directly to you afterwards. Finally, also very importantly for us, please do complete the feedback form at the end of the session. Let us know whether what you heard was of interest. And please, as importantly, please do, again, as we always ask, suggest any topics that you'd like to hear about in the future. It makes our planning sessions much, much easier if we know what it is that you all want to hear about. So that's plenty from me. I will hand over now to Katrina and Paul to tell you all about it.
Thanks, Alex. And thank you everyone for joining this morning to hear about the DMCC consumer aspects. So in terms of what we're going to cover today, we're just going to briefly touch on how we got here. Why do we have new consumer protection legislation in the UK? Then we're going to talk about the main compliance obligations. There's a big bucket of obligations about subscriptions, which I'm going to talk about, and then Paul's going to talk to you about reviews. And then we're going to finish up by talking about what's called the modernization of existing consumer law and also the sanctions regime. So just to kick off, how did we get to the DMCC? Well,
sorry, Katrina, I'm just going to butt in because I made a mistake when I did the intros. I asked everybody to use the chat function, the chat button at the bottom of the screen. Please use the Q&A button, not the chat button, because otherwise we won't get your questions. Apologies for that, and apologies, Katrina. I'll hand back over to you.
No problem. Good shout. So yes, Q&A, not chat. So the DMCC, how did we get here? Well, If we scroll back in history, the existing consumer law that we have in the UK is as a result of a series of EU directives that came out in the sort of late 90s, early noughties, and they were transposed into UK law because we were a member state and therefore have become a part of our body of law. And at the time when those directives were created and transposed, obviously we did have the internet, but was not the internet as we know it today. So those directives focus very much on sort of classic e-commerce relationships. We didn't have the existence of platforms in the way that we have today, and we didn't have certain specific consumer harms that come from those platforms, but also come from the rise of things like subscriptions and the use of reviews. So there has been a widespread recognition, and it's much bigger than the UK. You can see it in America, you can also see it in the EU, that some of this stuff, while still right, doesn't go directly to some of those new issues that the emerging, if you like, or the evolution of the internet has given us. So there is a general theme in legislation and consumer protection that we want platforms to take more responsibility for things, and that we also want to address some of the specific issues, which are sometimes loosely called dark patterns or referred to as dark patterns. And a couple of years ago, the EU did its own shift, which was called the New Deal for Consumers, where it looked at some of these issues, in particular reviews. The UK is now doing the DMCC, which is looking again at some overlapping issues with the EU. So the reviews are in there, but the UK is focusing very much more on subscriptions, which was not a part of the New Deal. But the EU has already moved on to what it's called its next refit. And the refits are their regular cycle of review of consumer protection law. And subscriptions and dark patterns are very much on the agenda there. So we have got this situation where the sort of broad themes and the direction of travel between the UK and the EU, and to a certain extent also America, are along similar lines, but they're not completely in step. And what is actually being asked in terms of compliance is a little bit different. So we do have issues arising for those businesses that are looking to have one compliance solution for Europe or even globally. The other thing that is worth noting in terms of the direction of travel is that increasingly legislators have noticed that very large, eye-catching fines have the effect of putting things on the board level agenda. And I think sort of GDPR has become the touch point for this. And therefore, one of the things that they are bringing in here is a new sanctions regime. And the point of the new sanctions regime is very much to empower the Competition and Markets Authority to actually generate kind of market level change in terms of compliance practices. And the fines are designed to make these issues board level issues that there is real focus and scrutiny on businesses. So that's the background of how we're here. As I mentioned, one of the biggest themes and focuses within the DMCC from a consumer point of view is subscriptions. And this is because there is a recognition in the UK that consumers are paying for a lot of subscriptions that they don't want or potentially don't need. And that's because they either have forgotten they have the subscriptions in the first place, or they actually are struggling to cancel them. And this is loosely called subscription traps. And it's sometimes referred to as a type of dark pattern. And in response to this, the UK government created a specific subscriptions compliance regime. So historically, subscriptions were just governed by the total normal consumer protection and compliance regime. Now we're taking it largely out of that and having a specific regime. And the regime has 4 parts to it. So the first thing is they are creating specific pre-contractual information requirements. So consumers are really clear when they are signing up, they understand that they are signing up to a subscription for ongoing payments. Nobody should be confused about that. The next part of the regime is that there are going to be regular points at which consumers have what's called a cooling off right. And a cooling off right is basically when a consumer has the right to cancel a subscription, no questions asked, don't have to give any reason, just because they don't want it anymore. And historically, we've only had the initial cooling off right for the first 14 days after you enter into the contract. We're now going to have regular points throughout the contract where the consumer has the right to just walk away in that way. The consumer is also going to get reminders that they are still in the contract and reminders that they have the right to cancel and how they can go about doing that. So that means from the point of view of compliance, there's going to be a lot of notices, probably in the form of emails, needing to go out to consumers. And then the final part of this is the so-called cancellation button. Now, for those of you who are familiar with the French and German legislation about cancellation buttons, this is not quite the same. Potentially slightly frustrating because otherwise you could just simply use your French or German cancellation button. But it's a little less prescriptive. It doesn't really have to be a button, but it does need to be an online, pretty friction-free way for a consumer to cancel a subscription. And if you are operating across multiple platforms, you may need to have buttons on more than one platform. So that is what we are seeking to achieve. And what this does in practice is it changes the consumer journey. So this is essentially what we have as a result of existing consumer law at the moment. So a consumer starts, they sign up online, they're given the standard pre-contractual information. They then have their 14-day no questions asked cooling off right, which will run in parallel with any free or discounted trial. They then would typically roll onto contractual terms, which would probably automatically roll, and it would keep going until a consumer decides to cancel in accordance with those terms. What the DMCC is seeking to create is something that looks more like this. And this is what your compliance program is actually going to have to deliver. So you're going to have new pre-contractual information, most noticeably a summary of the key terms, which will need to appear on the face of your user interface. So it can't be behind a tooltip. It mustn't require consumers to click. It has to be visible as part of the journey as they go through without actually taking any further action. They're then going to have their 14-day cooling off right as a result of entering into the contract, but they get another one at the end of any free trial or discounted introductory offer, and then they get an annual one. And meanwhile, they will also get a series of notices. Now, depending how your contract is structured, these notices might fall at slightly different points. But broadly, you're going to be sending notices upon joining at the end of any discounted free trial and then roughly 6 months thereafter. And that will keep going until such time as the consumer uses the cancellation button or cancels by any other means, by which might be in accordance with your terms, but also during those cooling off periods, the consumer has the right to just simply give you their own notice to say that they would like to cancel. And you then have to give them a cancellation notice to say that that has happened. So there's going to be a lot of different moving parts to bringing a subscription journey into compliance. And what I thought I would do now is just run through what a subscriptions compliance project might look like and the questions that you might want to ask. So probably the first thing you're going to want to think about is scoping. So there is this concept under the DMCC of excluded contracts. And excluded contracts are broadly, in the main, contracts that are regulated in some other way under a piece of other regulation. So that might be because it's to do with utilities, which is typically regulated elsewhere, certain life sciences related contracts, for example, to do with subscription medicines. But there are also some new novel exclusions created by DMCC, for example, micro food businesses. And there's an ability for the Secretary of State to create new excluded contracts. So it's a matter of keeping that a little bit under review. But assuming that you're not excluded from the regime, the next thing you're going to want to think about is whether your subscriptions are selling to consumers, to businesses, or to both, or maybe a mix of those two things. because this is going to have enormous implications for the scope of your project. Now, obviously, if you're just selling to consumers, that is really straightforward. You just do the consumer journey. But if you have got a mix, then you're going to have to make a decision, and you're going to need to engage with the business, because this is going to have big implications for your user interface and your flow. So there are a couple of options here. The first option is you build an upfront bit of your UI where you identify businesses and consumers and you route them down different consumer flows, which means you can then have a business flow which doesn't have all of this additional stuff from DMCC, and then you have a consumer flow that has all the consumer stuff in it. That's option one. Option two, which is probably more suitable if you only have the occasional business user, is that you say, well, you essentially deliver to the higher level. So you push everyone down the consumer flow because you say, well, you're just treating businesses more favorably, which you can always do under the law, and you essentially give them the rights that a consumer would get, probably contractually. The other option, if your business is more B2B focused, is that you actually make it exclusively a B2B proposition. You say, we're not letting consumers into this. And that point's really important, because even if you let one consumer in, that consumer has rights under DMCC. And those rights include the right to have all of this pre-contractual information, these cooling off rights. And if you fail to give that, that is not only an offence, but it also gives the consumer the right to withdraw from that contract and most likely get a full refund for everything they paid. So you do not want to have a B2B flow that you're allowing consumers down. So a bit of thought needs to go into what that stop is going to look like. And there are things that you can do building on existing case law to give yourself a bit of protection around that. So that's a situation that probably needs a bit more digging into. But assuming you've worked out now which route you want to go down, you now need to dive into your user interface review. And I always recommend doing this first, because in my experience, anything that involves software engineering is the thing that takes the most time. And we are looking at a regime that's going to be coming in probably early 2026. Now, for most people, that means now or in the next 6 months is the right time to be engaging with the software engineers about what needs to be done. And the other thing to bear in mind is most likely these days, you're not just doing one UI review, you're probably going to do at least two, a mobile and a desktop, and you might have other platforms. Now, as part of that, you're going to have to ask yourself some questions. So if you're an international business, are you just going to do this for the UK, or are you going to roll it out everywhere? If you roll it out everywhere, you're going to have to think how it fits with, say, the EU regime under the New Deal for consumers. You're also going to want to think about whether you've got any vulnerable consumers in there, because vulnerable consumers are entitled to additional protections. And the definition of vulnerable consumers has changed under DMCC, which we'll talk about in a minute. And also how you're going to deal with any space limitations, given that you're not allowed to hide things under tooltips or otherwise require consumers to click to make things visible. So that's going to mean that you're going to have to force other things probably out to make space for the new pre-contractual summaries. The next step on your journey is most likely a terms review. So you're going to have to draft this new summary of your terms. While you're looking at your terms, you're probably going to want to work out, based on the structure of your contract, when the notices are going to fall, so that you can start to think about notices. But also, I would suggest to you that you might want to look at your auto-renewal clause. Now, this is not strictly a DMCC point, but the CMA has issued new guidance about auto-renewal clauses. And the point to take away is that if your auto-renewal clause is not compliant, it is not enforceable, and therefore, actually, as a matter of fact, consumers will not auto-renew. And if you continue to take payments from them, then potentially you're not doing that in accordance with the contract. And there are moves in Europe in particular, some quite big moves for groups of consumers to try and claim back historic subscription payments over a really long period of time. And that's on the basis that the auto renewal clauses were not valid and enforceable. So it's always good to do a review, and particularly because we've got some fairly new guidance on that point. You're then going to want to think about the notices, because one of the things you will have seen here is that you do need to send out notices on a durable media. Now, it's most likely going to be an email, and those notices will need to be drafted, but also you're going to need to think about the systems involved, because actually, for an individual consumer, the timing will depend on the day the consumer enters into the contract, because it needs to follow their individual contract based on when they signed up. So you're going to need to have the systems in place to be able to send out those notices. And you're also going to need to think about what you're going to do about notices coming in from consumers saying they want to cancel pursuant to their new cooling off rights. How are you going to deal with those? How are you going to process those? How are you likely to receive them? Is it that people are going to walk into your physical premises and give them? Is it more likely they're going to call up customer services? What will that look like? And how will you make sure that those are actually actioned? And then the final piece of this is going to be thinking about that cancellation button. Now, if you've already got some kind of online process for people cancelling subscriptions, then it's going to be a matter of reviewing that for compliance with the new DMCC rules. If you don't have one, you might want to think about whether your German or French business, if you've got one, has one, because Germany and France also have somewhat similar legislation, so you might be able to leverage that. Alternatively, you're going to have to break the news to the software engineers. They're going to have to build you one, which I know will be unpopular. So it's a good thing to get on top of early. Okay. I'm going to hand over to Paul now, who's going to talk to you a little bit about reviews.
Thanks very much, Katrina. Good morning, everyone. Yes, so focusing on reviews and really what we're talking about is fake reviews in this sense, which have been in the government crosshairs for a little while, even back as far as April 23. We had a parliamentary report on the prevalence and impact of fake online reviews, estimating that at least 10% of product reviews on third-party e-commerce sites are fake, and leading to an increase in the proportion of consumers who would then buy these products based on at least the well-written fake reviews that are out there. Now, much like as Katrina touched on subscriptions, arguably fake reviews were already caught as an unfair commercial practice under the 2008 consumer regulations, as well as being a breach of the CAP code. But given the prevalence of this issue and the growing demand to deal with it specifically, we now have a specific offence in this area, as the government has added fake reviews as a blacklisted practice to list in what is Schedule 20 in the DMCC, i.e. something that will always or automatically be considered unfair. So when we're talking about reviews and what's caught, we have essentially three types of publication that fall within the scope. Now, the first is what we typically think of when we talk about fake reviews, or in this case, actually fake consumer reviews is the official way we describe it, which is defined in the legislation as a consumer review of a product, a trader, or anything else relevant to a transactional experience. So your customer service, for example, and whether that review is designed to promote your product or indeed denigrate a product. But the key point is that for it to be a fake consumer review, it must suggest that it's based on the reviewer's genuine experience, when in fact this isn't actually the case. So quite a broad definition there. And straight away, it actually sometimes introduces at least as many questions as it answers. So a bit of a theme of this section of the presentation, but we don't specifically know what a consumer review is. It's not specifically defined. One may assume it's where the review comes from someone acting or purporting to act in their capacity as a consumer, but we don't specifically know that. And also, how do you show or prove a review isn't based on a genuine experience? Sometimes that will be easier to show, where you can show, for example, the reviewer never received the product or service they're reviewing, but where they did, how does one show that the review or the views they have suggested or put up aren't actually their own or not their genuine views? The second type of publication, so incentivized consumer reviews that aren't disclosed. So the incentivization itself isn't an issue. It's the issue of disclosure or lack thereof, which causes the problem. But again, further questions here. What does incentivize mean? We don't have a specific definition here either, but the legislation elsewhere does refer to incentivizing by any means. So unsurprisingly, likely to be interpreted very broadly and go beyond just payment, but include things like provision of free items, price discounts, entries into prize draws if you submit a review, that type of thing. Though, of course, it'd be interesting to see what line the CMA takes on this. For example, is offering an incentive in and of itself to provide a review, is that likely to be caught? If you're just inviting a review, whether it's good, bad, indifferent, is that sufficient to amount to incentivization, or does there have to be some sort of implicit understanding that the review must be good, for example? How prominent does this disclosure have to be? Nothing on this, and I suspect that will be something that will come out down the line as we see how the CMA approaches it. But certainly it envisages it can be done in the review itself, but what other ways will be acceptable, and how obvious do they have to be? And finally, the third point, consumer reviews or consumer review information published in a misleading way. So actually not necessarily fake reviews at all. They can be entirely genuine ones, but say it depends on how they're used. And that could include things like where one produces an average rating of a product or service based on the reviews that have been compiled. So reviewers are asked to give a 5-star or up to 5-star review. You collate all those scores and produce an average rating. Where products are ranked based on the number of positive reviews, for example, or something certainly I've noticed relatively recently on Amazon, for example, it has a sort of compilation. I think using AI produces a summary of all the reviews and sort of mashes them together, produce an overall review. Again, something that would be considered consumer review information, and it's how you use that, whether it's used in a misleading way, which creates the offence. So those are the offences, and three primary ways we can see that traders may be affected by that legislation. The first, again, perhaps the most obvious, the creation of these fake reviews or the consumer review information. So this applies directly or indirectly, so whether the trader is creating the reviews themselves or getting others, commissioning others to submit those reviews, and indeed whether it's on their own platform, whether it's on third-party platforms, that is something that will be caught. It also catches traders who actually offer a review or information writing services, perhaps unsurprisingly. Again, interestingly, particularly in the case of incentivized reviews here, it's not clear how far the trader has to go to ensure that this disclosure occurs. Is it a strict liability offence in terms of if any review is published that isn't the incentivization isn't disclosed, is the trader automatically caught there? Or do they require some sort of knowledge on their part? Do they have to actively encourage the reviewer not to disclose there's been incentivization? Or is it somewhere in the middle? As long as you tell the reviewer that they should disclose that fact, or indeed build it into your contract terms, if it's a contractual relationship, how does that work? And so we'll have to see how that plays out. The second one, for those traders who are involved in hosting or publishing reviews, whether that's say for their own products on their own site, or indeed a third-party site that is publishing or hosting reviews on other people's products or services. The main point to note here is that the trader hosting those reviews has to take reasonable and proportionate steps to prevent such reviews or information appearing, i.e. stop them getting up in the first place, and removing those if they do slip through the net. Now, of course, lots of lawyers on this seminar, obvious question, what is reasonable and proportionate? And unfortunately, we don't know the answer to that. There's very little in the legislation. The idea is, the government indicated in early 24, they'll be working with the CMA to set out what steps traders need to take in this sphere to comply with the legislation. One assumes that's still the case, notwithstanding the new government. We have some idea based on how CMA have responded to this previously related to the government consultation. So it may well involve things like updating your policies to make clear what is and isn't permitted, carrying out regular risk assessments or internal evaluations of where the risks lie. Some sort of proactive system potentially who has to go out and try and identify and investigate these potential fake reviews. Third-party notification systems to allow people to report what they consider to be fake reviews, and the sanctions that you need to put in place to try and deter people from engaging in that sort of activity, whether that's, account suspension, blocking, etc. Again, what's reasonable and proportionate? Those are some of the measures that may be required, but will that depend on, for example, the resources available to the trader? Does it depend on the value of the goods or services in question? Does it depend on the importance of the reviews to that website? Some websites, TripAdvisor, for example, where reviews are critical to the integrity, the success of the platform, do they have to go further and conduct sort of more place more measures than somewhere where that isn't critical? Or simply because is it based on the amount of data that the trader has? For example, if you are sending products to reviewers, so that what they have and haven't received, are you obliged to sort of put more in place to detect whether those reviews are actually genuine, as opposed to somewhere where you have no idea whether they've ever touched that product or service? And finally, the moderating, collating, editing of reviews. This primarily is going to be where the trader is using reviews perhaps to promote themselves, whether again that's on their own website or marketing materials. Examples of how one might do this in a misleading way is taking only positive reviews, not showing the negative ones, giving greater prominence to positive reviews, admitting certain information in reviews. For example, the fact the review has been commissioned, or misattributing reviews, for example. So using a review of a standard edition product, as it were, or of a luxury or deluxe product, and using it for the standard one and creating confusion that way. Very quickly, just to say, it is worth noting that technically under this blacklisted practice, this will not be a criminal offence. Unlike most of the blacklisted practice out there, it will simply a civil one. But obviously the fines regime, which we'll touch on a little bit later, will still apply. So clearly this is something that has and will be taken very seriously.
Thanks, Paul. I'm just going to talk very quickly to you about the modernisation of consumer law that has come about as a result of DMCC. I'm going to rattle through this bit quite quickly because I want to leave a little bit of time for questions at the end. But very broadly, as I mentioned at the beginning, we have a number of transpositions of EU directives, including the Unfair Commercial Practices Directive, which we know as the Consumer Protection from Unfair Trading Regulations 2008, which has been restated in DMCC. And the point about restatement is it's essentially a sort of post-Brexit idea that assimilated EU law that has become a part of UK law in one way or another can be restated to modernise it and make it more appropriate to the UK. And this restatement has resulted in some changes to some of the concepts that underpin consumer law and also those blacklisted offences that Paul just alluded to. And it's also left us with some sort of somewhat open questions as to lawyers about what this all means in practice. And I just wanted to run through, this is by no means an exhaustive list, by the way. It is a few examples of things that are potentially particularly interesting or could have implications. So the first one is about the core concept of what is a consumer. Now, consumer law has always had a sort of binary concept of consumers and traders are people who are acting in pursuit of their trade, craft, or profession, and consumers are people who are not acting in that way. We now have this new concept of businesses, and traders are now also people who are pursuing business goals, and business goals include any undertaking for gain or reward, which potentially brings a little bit of clarity around some of the grey areas that we have historically had around people like influencers, particularly micro influencers, who might be doing it as a sort of side hustle on their if you like, real trade craft or profession. And it tends to suggest that if you are making money from something, that you'll be treated as a trader rather than a consumer under UK consumer protection law, which incidentally might be different in the EU because there is ECJ case law that goes the other way. So we could end up with a situation where there would be quite a different position taken in the UK in relation to people who have these kind of side hustles that they're doing under UK law versus EU law. We've also got a new definition of vulnerable consumers. Now, this is important because if you are targeting vulnerable consumers, then you have to do all your consumer law compliance through the lens of that group of vulnerable consumers. So if you are targeting children, for example, who are known to be vulnerable consumers, then everything you need to do will be judged by the standard of what would be misleading to the target age of child that you are looking at, which is established. But what has changed under the DMCC is we now have an express reference to what's called situational vulnerability. And situational vulnerability is when you don't have a characteristic like your age, which makes you vulnerable sort of as a sort of fixed thing, but rather it's about the specific situation you're in. Now, we have had historic enforcement on this basis in the UK, for example, in terms of funeral parlours. So the CMA said there that anyone who was in a funeral parlour, say buying a coffin, is probably grieving, and therefore they are situationally vulnerable, and the practices need to be viewed through that lens. But this is the first time that it has been coded into our law, and it's also become a factor in what is called aggressive practices. Now, historically, aggressive consumer practices have usually been enforced in relation to basically door-to-door salesmen refusing to leave people's houses or persistently pestering them. But I think this idea, bringing in this idea of vulnerability as a factor there, tends to suggest that we're trying to modernize that and perhaps opens the door to looking at aggressive practices in the online sphere. And that might help to get at some of the dark patterns that we know the CMA is concerned about through their online choice architecture enforcement. There are also new obligations in terms of communicating price. We now have a definition of total price, which not only includes taxes, so VAT, which it always did, but also any other charges that a consumer will necessarily incur. So it's trying to get at this drip pricing situation where the price increases as you go through the consumer flow. And we also know that variable additional fees are going to be looked at again, and there may be separate rules about these. We have a new offence, which is a specific advertising offence around an invitation to purchase, which is broadly an ad with a price in. And there is a list of information that has to appear in an invitation to purchase. It has been extended, and it is now a specific offence to fail to include this information unless it's not apparent from the context. So this is going to mean that there will be a much easier route to enforcement that doesn't require proving that that ad is misleading. And then the blacklisted offences have also been modernised. And the one that particularly jumps out at me is the persistent and unwanted solicitations, which used to be restricted to certain ways of communication, but has now been made, if you like, communication method neutral. And it means that this offence might now catch certain dark patterns like nagging, which is when you do like pop-ups, constantly asking consumers to maybe make a choice that you want them to make. So this will broaden the scope of that offence. And as Paul mentioned, because these offences are so-called blacklisted, i.e. always unfair, they are particularly easy to prosecute. And this one is, as a matter of fact, criminal as well as subject to the civil fining regime, which is created by DMCC. So all of these little changes will mean that we have a sort of slightly different set of rules in terms of the principles of consumer law to the EU. Most of the changes are subtle and perhaps don't massively change the meaning, but some of them will. And they also leave us with a lot of unanswered questions as lawyers. So, For example, what is the status of historic case law, in particular ECJ case law? Because a lot of the interpretation we do in consumer law has historically been based on European case law. Does the fact that this has been restated mean that that case law is displaced? What status does it have? Is it even persuasive? And it will probably depend on a case by case how much of a change has been made as a result of DMCC. The government's also given itself the right to create new blacklisted offences. Is this going to happen? I mean, there was a lot of talk as DMCC went through Parliament about maybe creating greenwashing offences. That could potentially happen now as a result of secondary legislation. We could also see things about dark patterns or anything else that becomes topical. And then the final question for me is, if you're operating in Europe, you need to have an eye to the fact that the EU is already embarked on its next consumer law refit. The last one created the New Deal for Consumers, the next one named to be determined, but it will be effectively New Deal for Consumers #2. And are they going to focus in on the same things as DMCC? We know subscriptions and dark patterns are on the list. They've been consulting on them. If they do go down those paths, is the compliance regime going to look like the UK, or are you going to have, as you have for reviews now, two bits of legislation, one UK, one EU, but with different underlying obligations that makes compliance across Europe difficult? So we are seeing much more of that divergence, and I think that that path will continue. I'm going to hand over to Paul now to just finish up by talking about those pesky sanctions.
Thanks, Katrina. And just very quickly, given the time, probably one of the reasons you're here, because you will have heard of the sanctions already. So, the headline point in the race to grab the competing attention of various legal and compliance departments in businesses across the UK, the breaches indeed can be subject to fines of up to 10% of worldwide annual turnover. Obviously, a hugely significant figure. We thought 4% under GDPR was quite draconian. The only thing to say, I guess, on top of that is it's designed to perhaps be a little bit more proportionate than the GDPR, which was 4% or £17.5 million, whichever is the higher. This is 10% of a global turnover or £300,000, whichever is the higher. So for very small businesses, the fine can't be more than 300,000. But ultimately, for the bigger businesses out there, the potential of fines if this goes wrong is extremely significant. And of course, for those in-house lawyers, that is the message that will be going out across to the business. The second point is that CMA can now enforce this legislation directly, essentially in a judge and jury type role. No need for legal proceedings through the courts. They can fine directly. There is still a courts-based regime for other enforcers, such as trading standards, the FCA, but the CMA can now go directly, which impacts that third point. Previously, the regime typically looked like CMA would try and get undertakings from a business in what they would or wouldn't do. And then if those undertakings were breached, then they would go to court. Will they still seek to use undertakings where they can now fine directly? Will they use this new fining power simply as a stick to incentivize businesses to agree undertakings more quickly? We don't know. This isn't designed really to cover the sort of the regulatory aspect, but of course it is something that will be interesting to see how that plays out.
Katrina and Paul, thank you very much. As ever, with these sessions, whenever I'm sharing, I've learned an awful lot about areas of law which I previously knew nothing about. So thank you very much indeed. We, as is quite often the case, we are running very short on time, but we will spend a few minutes, I think, addressing some of the questions which have come through the Q&A. We have had a whole host of questions. We're not going to get to them all, but we will, as I said previously, endeavour to answer those which we don't answer now. We'll try to answer them in writing later on. So there have been a few questions in relation to the reviews regime and quite a lot of questions in relation to subscriptions. I'll try and kind of pass them on in a as kind of intuitive way as I can, but I'll start with reviews because I think we can do that quite easily and succinctly, and then we can spend a few minutes on subscriptions. So in relation to reviews, the reviews regime, a couple of questions which came up related to influencer marketing, and firstly whether or not the regime bites in relation to influencer reviews, And secondly, I guess what in that context, assuming it does bite, what are some of the implications which businesses who engage influencers need to be aware of in this context?
Yes, thanks, Alex, and for those questions. And it's something we've thought about already. And the answer is we don't know, but I think it will turn on a couple of aspects. One is, and I touched on this in the slides, is in terms of influence reviews, particularly where that is, something they do. There's that commercial relationship. Is it a consumer review? Are they leaving that review in their capacity as a consumer? One might argue that's not the case. If it's not a consumer, in theory, that should fall outside the scope of this legislation. Of course, the CMA would say, arguably, they don't need this regime. Obviously, they have taken a number of action or enforcement actions in the past in relation to influence. So they may feel they don't need this, but equally, where they can, they may well add it to the list of charges. Two charges is better than one. But to the second aspect of that question, if the legislation does bite, what might a business do? And I think then that turns into the point I talked about in terms of disclosure. What's not clear is to what extent, if the business requires the influencer, the reviewer, to disclose that fact, whether they ask them or they build it into the contract, is that sufficient? Have they done all they can, or is it a strict liability offence? One would hope that certainly where you can show that you have taken measures to encourage the reviewer or the influencer to disclose that fact, then you've done what you can. But technically, looking at the legislation at the moment, we don't know. So there's two aspects to that, both unsatisfactorily unclear at this stage.
Okay, thank you. And also in relation to reviews, does the regime create direct or potentially indirect implications for those businesses who only advertise or feature positive reviews on their websites and leave all the negative reviews sort of unspoken, or certainly not given the prominence they might otherwise deserve?
It seems unlikely that you are stopped from simply just using positive reviews. I think it's more in the context of if you have a number of reviews, only sort of bringing up the positive ones or the negative ones. Obviously, if you adapt reviews to suit your purposes and cut and paste the choice bits of a review, that's probably likely to be caught. Similarly, if you use reviews, you choose a review to use, and that's been an incentivized review and you don't disclose that, then that probably would be caught. But I don't think on the face of it, it is designed to simply stop companies using positive reviews in their own promotional materials. I guess the other thing that brings to mind is perhaps if you have one positive review and 100 negative reviews and you take the one positive, then arguably that might be caught. But I don't think, in theory, it's designed to simply stop you using positive messages in your own promotional materials, because that really would be quite a draconian response.
I agree, Paul, but I think it is important that you're clear about what you're doing, because the law draws a distinction between testimonials, which is effectively that, which is pulling out one review and presenting it as a testimonial, versus showing a body of reviews. If you are going to select positive reviews and use them as testimonials in your advertising, it needs to be presented like that to consumers, and that they understand this is an ad where you have selected a positive review. It can't be that you present it as if this is the entire body of reviews, because that is absolutely misleading use of reviews.
Quite.
Okay, thank you both. We'll move on to deal with to address some of the questions in relation to subscriptions, and they fall into a couple of categories: timing, scope, and exclusions. So in relation to timing, if you just reiterate and provide a bit more clarity on when the subscriptions regime comes into force.
Well, I can't, because we don't know for sure yet, is the long and the short of it. So the legislation was passed as part of the wash-up when the general election was announced. We were told at that time that the main part of the consumer provisions of DMCC would come into force this autumn, and the subscriptions would be early 2026. Obviously, we now have a new government, so the if you like, the Secretary of State who presses the trigger button to say go is now a different Secretary of State. We haven't had an update since the election. It is possible today in the King's Speech we might get one. So hold that thought. But that said, Labour have been incredibly supportive of this legislation. I don't know of any reason to think that those timings aren't still broadly right. So I would suggest that that is what you should be telling the business at this time. But, we will certainly be monitoring very closely what happens through the King's Speech and everything else. And, happy to share what we learn in due course.
Okay, thank you. And when the regime does come into force, will it have retrospective effect in any sense in relation to existing subscriptions? Will businesses need to go back and essentially backfill, or in terms of provision of information, or start providing notices and opportunities to cancel which were not an obligation once the subscriptions were first
I
subscribed
mean,
to?
subject to any guidance on it, I think almost certainly you won't need to backfill the pre-contractual information because once someone is in a contract, I think there is a reasonably good chance, but it's uncertain, that we will receive guidance that suggests that everyone should get the notices. And get the rights that you get, if you like, once the contract is in force. I think it's very unlikely you will be asked to go back and give pre-contractual information.
Okay, thank you. Just briefly, in terms of scope of the subscriptions regime, one question that came up: will it apply in relation to free subscriptions when the subscriber isn't paying?
No, the definition of a subscription involves a payment. So, and pretty sure at this stage that means money, not payment in any other form, because usually the word payment doesn't extend to, say, personal data. So it's about giving something. It's quite clear that it could be quite a wide range of somethings. It could be actual goods, it could be a service, it could be digital content, but it's giving something in exchange for the consumer giving some money.
Okay, and how about charitable donations, where people sign up to pay monthly donations, for example?
I think that's one that would bear closer scrutiny. So there are going to be edge cases here, and also particularly in relation to application of the excluded contracts. And for some people who are in those kind of businesses, I think it's going to be a matter of doing a quite detailed analysis of how all of this applies. And it might be quite fact specific depending on the charity, because charities are structured in different ways. Some charities do arguably give something in exchange. Maybe if your charitable donation is in the, like, sponsor a penguin in your local zoo, you might get updates on that penguin. Perhaps that is a subscription. So I would say that's one where you would need a closer legal review, quite a detailed legal review, to work out if you're in scope or not, and you might want to restructure to make sure you're not.
Okay, thank you. And that answer actually answers a number of the other questions which did address very sort of specific businesses and whether or not subscriptions in respect of particular businesses fall within the excluded categories. I think the answer to that, and reading the questions, my thinking was, that's not something I can fairly ask you on this.
No, I think all of this, this is new legislation, and where there's very specific questions about very specific types of contracts, that's something you have to dig into on a case-by-case basis. We'd obviously be delighted to help.
Okay, thank you very much. Look, I think we have run out of time. There are some more questions, but I think we've covered the main themes, and those we haven't answered, we'll endeavour to get more specific answers to you. So just to wrap up, again, some housekeeping. Please do answer the feedback forms, provide suggestions for the kind of topics that you want to hear about in the future. It's massively helpful for us. Secondly, very importantly, thank you very much to Katrina and Paul for all the work that's gone into the prep of this and also the delivery of it. It's been very clear, very helpful, very illuminating, certainly from my perspective. And finally, thank you to everybody who's attended today. We hope you find it useful. We hope you attend future sessions. We're taking a short break over the summer. There won't be an August in-house in focus. The next session will be in mid-September, and we'll be sending round details in relation to that so that you can sign up in due course. Thank you, everybody.